02, the Court of Appeals, the appellate court, will not issue a judgment which renders final that appeal until either the parties agree not to file a petition for review or that period expires, which under the rules is 30 days.
Well, let's stop there. Mr. Nelson, what's your intent there?
Your Honor, the defense will be filing a petition for further review.
All right. Mr. Craig.
So then, Your Honor, it is our position that because the judgment has not issued, this court does not have authority to consider matters that affect the order appealed from. And this is a pretrial appeal. State's pretrial appeals are strictly limited to situations where the state can show a critical impact. And that was done in this case because the charges obviously affect what goes on in the trial. That becomes a measure or a piece of pretrial litigation, appeal, because jeopardy would attach during a trial and prevent the state from seeking those charges later. So the whole basis of the appeal that's currently pending is jeopardy. So therefore, everything involved in this appeal is that which is necessarily involved in the trial. So it's our position that while this appeal is pending, the court doesn't have authority to hear matters that are involved in the trial.
It just seems that's a bit tenuous, Mr. Frank, to say it involves everything. I agree. The appeal was clearly on whether I should reinstate the charge of murder in the third degree. Right. That was the subject of the appeal. And they reversed and remanded to this court for that purpose. That's fairly narrow as far as everything going on in this case. And so I agree, jurisdiction has been removed from the district court on that issue and remains with the Court of Appeals and possibly even ultimately the Supreme Court. But it seems that everything else is not related to that appeal. It was fairly narrow, and we can proceed at least with other motions in limine, with jury selection, and figure out where we're at on March 29th.
And Your Honor, I think I'll start with jury selection because I do think that's fairly important. This court will have to be making decisions about seating jurors for that trial, a trial that we don't know what the charges will be in yet because of the pendency of the appeal. I maybe should start with actually the motion. Originally, the state had brought this motion to reinstate the third-degree murder charge, allow the third-degree murder charge back in as one of the charges in the case as it had been originally. That the Court of Appeals remanded, finding the legal basis that the court had used was wrong, but allowing the court to hear that motion still. Clearly that motion cannot be considered. That means we won't know exactly what the charges are if we were now go forward and start picking the jury. So this court would be making decisions about jurors for a trial about which we don't know what the exact charges are going to be yet. And that jeopardy, once it attaches, that clearly cannot happen, right? Because that would prevent the state from retrying the defendant, trying on new charges. That's why it's necessarily involved. So having the court go forward and deciding things as important as who the jurors are for that trial, we believe is necessarily involved in the appeal because it is the very charges to be adjudicated in that trial.
Well, let me stop you there. Generally on a homicide case, there are multiple charges, multiple degrees, some murder, manslaughter. This is not unique to this case. And the state, let's assume there was no murder 3 ever in this case. And we got to the end of evidence, and the state asked for the court to submit murder in the third degree as a lesser included. That goes to the jury. The jury never heard about it beforehand. You didn't necessarily have it at the start of the case during jury selection. Wouldn't your argument invalidate that whole process about asking for lessers at the end of the case because we didn't voir dire on it, we didn't talk about it? What are your thoughts?
Well, Your Honor, first of all, it's a condition that we can't depend on. It is conditional, and our motion was to have those charges at the beginning of trial. And so our motion is to try the case that way, not have it brought in as, or try to bring it in as a lesser included later, if it even is a lesser included. We're all familiar with the Dahlin standard and how that might apply to allow that subsequent amendment, but it's not the way we want to try the case. And so that is why we asked the court ahead of time to allow it, to be very specific about the charges involved in the case from the very beginning.
And I agree with you on that. My point being that the fact that any party in any type of homicide case can ask for lessers that were never even in front of a jury during jury selection, doesn't that say that it is not necessarily part of or affected by the absence of a third-degree murder case or charge in this case?
I would say, give you the same answer, Your Honor. That's not the right way to try this case, because we want those charges now and fully presented to the jury during the trial, without having an argument later that that's not how we tried the case, and now you're asking the jury to consider something that hadn't been a part of this case and presented that way. We want it litigated. We moved as fast as we could, of course, once the Knorr decision came out, because we want it part of this case. We want it all out in the open. We don't want to wait for a condition later that we may not get satisfied when the jury is sitting there. So the other problem...
Well, let me ask you a little different question, which is, to follow your logic, is there any time when you have a subject of appeal, because you agree, jurisdiction has been taken from the district court on the subject of the appeal, the third-degree murder charge. And if I acknowledge, we can't really act on this. In fact, I can't even hear argument or motion on the merits of whether third-degree murder, because the Court of Appeals did remand it for, if the defense had any other reasons to deny the motion, that they could bring those. And I agree with you, because I don't have jurisdiction, I can't even hear argument about that. But your argument seems to make it that the rule is jurisdiction is taken from the district court for the subject of the appeal. And with your logic, is there any case where the whole case would be stopped by an appeal? In other words, that it's not just about the subject of the appeal, but because it might have effects on other parts of the appeal, the entire case is put on stop. Give me an example of something where that would not be the case.
Your Honor, as the rule allows exceptions, there may be some things this court can do. Right? There may be some housekeeping motions, things that won't affect the substance of the trial that the court could hear. But when we start to get into matters that are so involved in the trial itself, such as the charges, the jury instructions, what the potential jurors are told at the beginning of the trial, you create an appeal issue that will only be resolved after the case has been tried. And Your Honor, we're not trying to delay this case. We want to try this case, but we want to try it right. And we only have the ability to try it once under certain circumstances, right? So we don't want to create appeal issues that are, stem from the court's jurisdiction. It's not something defense can waive or agree to. It's the authority of this court to hear a matter. And so it's creating an appeal issue where we shouldn't be, and we can avoid it. And I do think that, as I said, the rule recognizes exceptions. There are things we can probably move forward on, some basic and simple motions. But the other problem with jury selection is, there's a 30-day window to file a petition for review. The defendant is entitled to take all that time if he wants. There is a response period of 20 days, and we would try to respond obviously much quicker than that. And then the Supreme Court has 60 days to decide whether to grant the petition or deny it. And only then, if they deny it, the judgment would issue. If they grant it, as we all know, that litigation could take months and months. So if we start picking a jury, it's likely we would get 14 jurors well before any of those deadlines could happen and a judgment issue. So then we've spent time picking jurors that may not get used, but still the most, and just having them sit while deadlines go on. But the bottom line is we're creating a potential problem that cannot be waived, cannot be agreed to by the parties. So in deciding, I think the parties have a right to some extent to voir dire jurors about those charges. I know full well attorneys need to be limited in how much they can ask jurors about the law, but I think we have...
I think you know that I'm very actually strict about that, probably to the extreme.
And I do understand that, but I do think the parties have to be given some leeway to ask about charges. The jurors have a right to know. They started jury selection being told something very general, and then later they're told something very specific. I think it does affect the jury selection process, and so it is, in our position is it is very much involved the trial itself, because what we're dealing with are the precise charges that the defendant will face and that the jury will be asked to resolve.
All right, I'd like to hear from Mr. Nelson. Would you mind approaching the lectern, and I'd like to ask your opinion on several things. Mr. Nelson, let me start. I think there are two issues here. Do you agree that as far as entertaining the motion to reinstate murder in the third degree, that I do not have jurisdiction to even entertain argument about that at this time? Would you agree with that?
I would agree, Your Honor, that the court does not have jurisdiction to issue an order until we hear from the Supreme Court. However, I would disagree that the court can't even entertain argument on it.
Okay. Let's assume that I decide otherwise, that I don't have jurisdiction even to consider argument because jurisdiction is currently at the Court of Appeals on this issue. What's your view as to the extent to which jurisdiction has been transferred to the Court of Appeals? And are we, as Mr. Frank has said, limited to, we essentially have to shut everything down right now and wait?
No, Your Honor, I actually think that the rules of criminal procedure are very clear on the point. Rule of Criminal Procedure 28.04, subdivision 2, paren 8, the last paragraph specifically says, this is the provision dealing with pretrial appeals by the state. The last paragraph specifically states that an appeal under this rule does not deprive the district court of jurisdiction over pending matters not included in the appeal. Because the only issue pending in the appeal is the reinstatement of the murder in the third degree charge, that means that everything else is within the court's jurisdiction. There are two additional charges, murder in the second degree as well as the manslaughter charge, jury selection, motions in limine. All of these things can be accomplished. I just wanted to inform the court that we're prepared to try this case. It is not our intent to cause delay by filing a PFR with the Minnesota Supreme Court. However, I feel I have an ethical obligation to my client and to other criminal defendants to do so because it was a published precedential opinion. We're prepared. The petition for review is actually prepared, subject to some minor edits that we need to do. So I intend to file this petition post haste, Your Honor. We have a 3-week window of time where we can accomplish a lot. I mean, theoretically, I could file the petition for review tomorrow. Let's say I did that, or later this afternoon even. If the Supreme Court receives that, the Supreme Court, just like in the Newark case, could act very quickly. They could grant or deny it very quickly, and we're right back here, or we're up at the Supreme Court. So I don't think that the court is deprived of jurisdiction over anything other than the consideration of the murder in the third degree charge.
All right. Mr. Frank, anything else you'd like to say? And I'll need you near at the lectern again. Yeah. Anything else you'd like to say?
Yes, sir.
Okay. Thank you, Mr. Nelson.
Just as a final point, Your Honor, it is, I think, very important too, when we talk about voir direing the jury, that the jury be selected and voir dired as close to the trial itself as possible. If we do end up picking jurors and then a charge gets added, presumably we would have to go back and re-voir dire jurors about any press that got and any other matters that had come to its attention. We'd simply be repeating some of the voir dire. I realize it wouldn't be the same. I'm not suggesting that. But it would complicate the process and build some repetition into it. I agree with Mr. Nelson. As I said, we're ready to go today. We want to go today. The defendant has the rights to pursue that appeal. We don't dispute that. He has the right to do it in the time periods provided under the rules. We're not doing this to interfere, to slow this down, but it is a very important matter, as I've said, that deals with the practical realities of picking a jury and the charges and the court's authority to even hear it, which is, I mean, what essentially defense is doing here is potentially building in an appeal issue to rely on later. So
but everything the court does is a potential appeal issue. So I guess I'm not persuaded by that. We've kind of done this backwards because I've asked for argument before you actually have a motion. What relief are you requesting?
Your Honor, what we're asking the court to do is to, I guess the term would be to stop the jury selection process at this time, let that PFR get filed. I think that we could get together and decide if there are some motions that we could hear. They would be rather simple and motions and could move forward potentially on those. But I will be candid with the court that I think we will be very cautious in what motions we think we can handle for the very same reasons, because they just create appeal issues later.
Understood.
But we are asking the court, and we would file a formal motion if the court needs us to.
The oral motion is
to basically stay the jury selection process until that petition for review by the defendant runs its course.
Which would pretty much put us at least 30 days out probably, because it's not only, even if Mr. Nelson files it tomorrow, the Supreme Court still has to act on it. And then of course we have the whole problem with the judgment.
And Your Honor, I'm sure that we would, I may be speaking a bit ahead of my teammates, but we would move expeditiously, of course, in responding to the PFR. I suspect the Supreme Court would as well, but I certainly can't speak for them. But we would try to be expeditious in the process too, of course.
All right. Well, the court's view is that I don't have jurisdiction to consider in any way reinstating the murder in the third degree, because judgment has not been entered by the Court of Appeals, and so jurisdiction has not been passed back to the district court on that issue. However, I do find that the other matters, including jury selection, are not matters related to the appeal and that we should go forward on them. And so that's the court's order. I expect that we will do motions in limine. I find that those are also not related to the appeal, except if there's anything about murder in the third degree, but I don't think there is from my review of the motions. And we summoned the jurors for 8:30. I don't know if they've all reported by now, but they also have to watch the standard jury orientation video. The idea was that we would start jury selection at 9 or 9:15. This is what I suggest. We take a recess at this point, because clearly you are within your rights at this point, since you think I may be acting without jurisdiction, to seek a writ of prohibition. And so I'll give you some time to talk to your team and see if you want to get that started.
Thank you, Your Honor.
All right. Mr. Nelson, anything further?
No, Your Honor.
All right, we are in recess till at least 9 o'clock. Thank you.